Hello and welcome to a webinar about the AIA contract documents new facility management family of contracts and forms. This is a set of documents that we have been working on intensely over the last several years, and I'm very excited to be able to share some of the features and benefits of using this set of documents. Now, if you know the name AIA contract documents, you likely know that we have a long history of providing standard form contracts for the design and construction industry. In that time, AIA contract documents has come to be known as the industry standard when it comes to providing standard form contracts for contractors, architects, engineers, subcontractors, and many more other parties to construction projects. However, the facility management documents that are the subject of this webinar truly are a first for our program. This is the first time we have ever published a set of documents aimed not just at the initial construction of a project, but at the day-to-day operations and maintenance activities that make up the bulk of the operational lifespan of a building. And I think I can confidently say that these documents are the only coordinated set of facility management contracts and forms available in the United States today. Now, from a personal perspective, as an attorney who has often represented property owners in private practice in the past, I can tell you that this family of documents is long overdue in our industry. I have spent hundreds of hours negotiating maintenance contracts in years past, and I cringe at the thought of how much time I could have saved had these documents been available to me back when I was in private practice. So over the next 30 minutes or so, we're going to be giving you an overview of this new set. We'll give you a little background about why we created these documents, what kind of professionals they are suited for. We're also going to give you some insights into the important choices we had to make when creating these documents, and we'll preview some of the more important provisions so you'll know about them in advance of using them. My name's Mike Koger, the guy on the left on the screen. I've been working at AI Contract Documents Program for the past 11 years. I started my career as an architect, and I have also worked in private practice as an attorney before working with the AI Contract Documents Program. Joining me on this program is Elisa Schneider. Prior to joining the AI Contract Documents team a few years back, Elisa spent over 15 years in professional construction and legal pursuits, which included the management of a private construction company, practice as a construction defense litigation attorney, and also as in-house counsel, where she negotiated, drafted, and managed construction contracts, facility management contracts, and other real estate transactions. So now that you know that both of your presenters are attorneys, I have to make the obvious disclaimer that we cannot give you legal advice as part of this presentation. What we're going to do in the next 30 minutes or so is we're going to describe the standard form contracts in our facility management family. We'll describe some of their key features, how you use them, when they're appropriate for use. But if you do need legal advice, we recommend that you contact an attorney in your jurisdiction who can help you out with your specific problems. So I want to first start by addressing the big picture question of what is facility management. The definition you see on the screen here is from IFMA, which is the International Facility Managers Association. This is the leading trade association in the world for facility managers. And as you can see from this definition, facility management is a far-reaching interdisciplinary field of work. It addresses numerous activities connected to a built project. Now, as you might imagine, we at AIA Contract Documents are most concerned with facility management activities that fall within the realm of physical maintenance, upkeep, space planning of existing buildings. In other words, while facility management is a field that goes well beyond the physical upkeep and planning of an existing building, the contracts and forms in this new facility management family of documents are going to be focused on those core activities. So it's certainly true that facility management includes things like business continuity planning and emergency preparedness. Just know that our family of documents are not going to address those issues. What they will help you address is things like HVAC maintenance, janitorial services, landscaping, groundskeeping, and all those other things that you need to hire people to do to keep your building up and running. So here is the complete list of documents in our facility management family. We believe this bundle will be of particular use to anyone who is responsible for the upkeep of existing buildings. Now, of course, that could be property owners, but it also could be facility managers, property managers as well. These documents could also be used by a variety of maintenance contractors or consultants who are regularly doing work on existing buildings. And as for the bundle itself, it includes a set of maintenance agreements which fall into a couple of different categories. You can either use a master agreement with work orders or standalone agreements, and we'll provide some more on those distinctions here in just a moment. We have also included a purchase order, which is a streamlined agreement that is commonly used for buying goods or other movable items. So if you're a property owner, you might use this F-104 document, the purchase order, to buy things like equipment, furniture, or other items for your building. We also have 2 new consulting documents as well. These can be used to hire many different types of consultants that a property owner might need during the operations and maintenance portion of a building's life. We also offer forms that predominantly tie into maintenance agreements. That includes all the documents in the G700 series, such as an amendment, an invoice, a request for certificate of insurance, a status report, an authorization to proceed with early release work, and an RFI. These are just common forms that you're going to need when you're hiring maintenance contractors for their kind of ongoing activities that the maintenance contractors do. We're also going to do more webinars in the future where we go into more depth on all of these documents, particularly the forms. But for today's purposes, we're going to mostly talk about the core agreements that are at the top of the slide. We'll talk about the forms in more depth at subsequent webinars. So now that I've shown a preview of the documents that we're going to discuss on this webinar, I want to briefly touch on the AIA Contract Documents Program, which I believe is a truly special program and methodology for creating standard form contracts. At AIA, we have been publishing standard form agreements for design and construction activities for nearly 140 years. That is not a typo, almost 140 years. And I do think it is important to understand how we create documents, the process we go through, and our goals in drafting standard form agreements in order to determine whether our offerings are right for you. So first, we go to painstaking lengths to make sure that we are reaching out to people in the industry to craft documents that are responsive to your needs. We are supported by the AIA Contract Documents Committee, a team of attorneys, as well as other industry professionals, and we spend a lot of time trying to get these documents right. In all of our work, we are always striving to create documents that are fair and balanced to both parties. We are also aiming to conform our contracts to the common law position in the majority of jurisdictions in the United States. And we also try to allocate risks and responsibilities to the party who is best able to control those risks. Now, there are several benefits to using coordinated standard form contracts if you're a property owner or a maintenance contractor. From personal experience, I can tell you I've spent many hours negotiating provisions back and forth with attorneys on the other side of the negotiating table, only to end up just defaulting back to standard AIA provisions because neither party could convince the other to take on an outsized portion of risk. So if you start with a contract that is fair and balanced, like an AIA contract, you can more quickly get to an agreeable position, and you can limit the amount of money that you need to spend on hiring attorneys. Also, even if you do need to negotiate or edit contracts, and hire an attorney to do so, which we do, of course, encourage folks to hire attorneys when they're completing and negotiating our agreements. The last thing an attorney wants to do is start drafting with a contract from scratch with a blank piece of paper. So starting with a standard form agreement is always a good place, even if you are hiring an attorney. Even for specialized conditions in jurisdictions that might have enhanced or atypical contract requirements, you'll probably find that our standard contracts get you 85 to 90% of the way there. And you'll only need to hire an attorney to solve for those remaining 10 or 15% of issues that truly require jurisdictional or project-specific knowledge or input. Also, if you are maintaining a building or a collection of buildings, you are likely hiring dozens and dozens of maintenance contractors of some sort. And when I was in private practice, this is certainly the scenario I ran into very often. If you're simply just signing proposals from maintenance contractors and using them as the basis of your contracts, you have invited a bit of chaos into your life as a property owner or a manager. Not only does that mean that all of your contracts are going to be written to benefit the contractors that you've hired, because you're signing proposals that they write, you have zero consistency when it comes to the basic business terms of your engagements with these contractors. Every contractor is going to be entitled to payment on a different date by a different schedule. All your warranties are going to be written differently. So, and also if you have to terminate a contractor or resolve a dispute, the terms on which you do those activities are all going to be a little bit different. This facility management bundle of documents can help solve those problems by standardizing the business terms for your maintenance contractors and consultants. So have common payment provisions so that everyone's paid on the same day, same month, have common dispute resolution provisions, and so on. And Lastly, before I turn it over to Elisa to talk about our maintenance contracts, I think it's helpful to consider the life cycle of an average building, particularly when it comes to evaluating your needs as someone who owns or is otherwise responsible for maintaining a building. And for this exercise, I'm just imagining the life cycle of a building expressed in terms of minutes within an hour on the face of a clock. I mean, of course, most buildings are going to start off as an idea, a need for new space, and the first, minute or 2 minutes or so of the lifespan of a building is really made up of designing the building, going through the permitting process, doing programmatic or programming needs to determine spatial needs of your building. The construction portion of a building's life is also relatively short. It's a very intense period of time in a building's lifespan, but it's very short as well. But it is this large yellow section of this diagram that's on the screen here, where these facility management documents are going to be of most use to a property owner. Now, of course, AIA contract documents offers hundreds of standard form contracts and forms for the initial design and construction portions of a building. Now we offer a set of documents to assist in the operations and maintenance, the remaining life of a project as well. So, Elisa, I have been talking on and on for the last 10 minutes, but I want to bring you into the conversation to start us off by talking about why it is very difficult to use a contractor agreement to hire a maintenance contractor.
Thanks, Mike. Yes, so you may be thinking at this point, why can't someone just use a regular contractor agreement to hire a maintenance contractor? And the fact is that people absolutely do use our owner contractor agreements to hire maintenance contractors. And it's not because it works particularly well, but because there's really no other options. Really, everyone who's tried this has become unbelievably frustrated with it. If you do use them, it can be very time consuming to modify the contracts to fit the maintenance work. And if you're going to do it right, you need an attorney to do it. It's also important to note that the key differentiator between a regular contract agreement and a maintenance agreement is the scope of work. With maintenance work, this typically involves ongoing routine tasks instead of a single defined project with a clear endpoint. Also, maintenance work typically aims to maintain or restore existing systems or areas at a facility to keep the building and facility operational rather than completing something new. So, based on that, let's take a look at some of the reasons why you wouldn't want to start with one of our owner contractor agreements to hire a maintenance contractor. First, maintenance contractors do not work towards substantial completion. The work really does not always have a quote final state that can be reached in the same way as a typical construction project. Second, maintenance contractors are usually paid through invoices and not payment applications. Maintenance work by its nature is typically straightforward and really doesn't require detailed breakdowns found in payment applications. So, invoicing just offers a simpler way to bill for smaller tasks like repairs, inspections, or routine upkeep. Third, maintenance work rarely involves any significant design or structural changes. So, maintenance contractors are less likely to be working with design professionals. Fourth, the maintenance contractors typically perform work underneath a maintenance or master agreement and work order. This structure provides the flexibility and efficiency needed to complete the work. In general, master agreements set the overall terms and conditions for the long-term relationship, and the parties can avoid renegotiating terms each time the work is needed. Then the work order allows the parties to negotiate specific terms for each job. This would include things like the scope, the timeline, or the cost. Then finally, looking at this, we have, the reality of maintenance work is that maintenance contractors have more interaction with the people in the building. Sometimes maintenance work can directly impact the safety, comfort, and daily lives of people using the building. So, maintenance contracts can set clear guidelines to ensure that maintenance work is conducted professionally with little disruption and really ensure that the potential risks that are associated with the work are managed effectively. I think it's also really important before we get into the types of maintenance agreements that we offer. I think it's also helpful to look at another aspect of the maintenance work itself. Maintenance work typically falls into two distinct work types. We first have ongoing services and as needed services. If you look at ongoing services, these are the type of repetitive maintenance needs that are regularly performed as part of a building's upkeep, really just to ensure that things remain functional, safe, and efficient. So here you might consider doing duct cleaning for your HVAC systems. You might consider mowing or snow removal or roof inspections. You might also need to do some sealing or pest control. As an example for as needed services, these are more discrete building repairs or simple improvements that are really meant to remedy a condition that has failed or malfunctioned. So here you might have a roof or window leak. You might notice that your parking lot needs to be restriped or that your HVAC system has some kind of leak in it. In that case, this would be an as needed service. And so, with that understanding, I think it's now a good time to talk about what contracts we offer. And we offer two distinct contracting methods that you can use to hire a maintenance contractor. You can utilize a maintenance agreement that is a master agreement and couple that with an associated work order, or you can use a standalone agreement. With the master, I think we'll talk about the master agreement method and work order method first. The F101 2023 master maintenance agreement is used when a contractor will have reoccurring work with the client. This particular method of contracting is intended for when the scope of the maintenance work will be subsequently defined through one or more work orders. Master agreements can be used when the contractor performs services on several different properties. It can also be used where the contractor's services will be phased according to a location or completion schedule, for example. The F101 in this case, as the master agreement, provides the common terms and conditions that will be applicable to each work order. These common terms would include general roles and responsibilities of the parties. Examples of that would include how payments will be made, general insurance terms, and termination terms and conditions. Then, as it relates to the work order, the F101 Master Maintenance Agreement is coordinated for use with either the F201 2023 work order for as needed maintenance work or the F202 2023 work order for ongoing maintenance work. Each work order will provide the information about the scope of work, the schedule, the compensation, or really any other special considerations that are associated with that piece of work. This could include things like payment terms, or if there's special insurance requirements that are different than what's found in the master maintenance agreement, the parties could identify that within this work order. And then when a master agreement is paired with a work order, this creates a work order contract that will provide the terms and conditions that govern the scope of work included in the work order. Second, we have the standalone agreement method. So standalone agreements are used when a contractor will not have reoccurring work with the client. AIA Contract Documents offers two standalone agreements. The first one being F102 2023 Maintenance Agreement for As Needed Maintenance Work. And then we have F103 2023, which is the Maintenance Agreement for Ongoing Maintenance Work. These standalone agreements offer terms and scope both for the maintenance work in one form. Unlike the master agreement, a separate work order would not be needed in the standalone agreements. So I'd like to take the time to discuss some of the contractual provisions that you're going to find in our maintenance contracts now that you know what maintenance contracts we offer. As Mike mentioned, given our time today, I can't dive deeply into each topic, but later this year, we do plan to do a deeper dive into terms and conditions and other aspects of our maintenance documents and forms, particularly through the entire list that Mike mentioned earlier in the presentation. But starting out, I'd like to look at payment process. Traditional construction contracts tend to have a complicated payment process, and really for good reason. In a construction project, it's usually very difficult for an owner and their lender to understand if they're getting what they're paying for just by looking at the progress of the work. So that's where payment applications come in handy. Maintenance work, as I mentioned earlier, is far more straightforward. So for that reason, our maintenance contracts include a much more simplified invoicing process, which means no application for payment, no schedule of values, no architect certification. Simply, the invoices need to include the description of the work, the location of the work, the dates when the work was performed, and then the contractor submits the itemized invoice at the first of the month, and the payments due within 30 days. I should note here that the client can require the contractor to include additional support on invoices, and that would be things like releases and waivers of liens, or really anything else that the parties negotiate that would be helpful for them. Then if we look at the scope of terms, or the scope terms in this agreement, maintenance contractors, as I mentioned, really have more interaction with people in the building. So our maintenance contractors contracts include fill points for parties to describe any requirements needed to access the facilities and any work schedule restrictions that might apply. So this could be limited hours where, or limited days where work can take place. This can really help kind of set the clear guidelines to ensure that the work is conducted without much disruption to people inside the building. The next thing that we want to look at is consequential damages. So our maintenance contracts include and continue to include a mutual waiver of consequential damages, which has been standard in our contracts since 1997. As a general reminder, consequential damages relate to the indirect losses that arise from a breach of contract. So, in the case of a client, this would include loss of use, loss of income, loss of profit, and loss of employee productivity. For a contractor, on the other hand, it could include lost profits or even reputational damages. It's helpful to note that prior case law has reminded the construction industry of how unpredictable and outsized assessment of consequential damages on a project can be. So, really, including this mutual waiver removes the uncertainty related to these claims and mitigates the risk of either party facing damage awards that far exceed the value of the underlying contract. The next thing is indemnity. We all know if something goes wrong on a project, damages to the client could be significant. So it's not unreasonable to expect a client to want the contractor to agree to indemnify the client for damages resulting from their work. Indemnity provisions can, by their nature, be very confusing and very frustrating, and they can significantly shift the liability from one party to the other. And there's a lot of information out there to help you navigate the tricky indemnity language, so I'm not going to dive into that today. But what I do want to highlight is that our maintenance agreements include an example of a fair indemnity provision where the maintenance contractor indemnifies the client for damages and losses arising out of the maintenance work. The indemnity also includes attorney's fees, but does not include the duty to defend. Now, this is important because based on the duty to defend, some courts have required contractors to pay for defense costs even before fault has been established. Finally, our indemnity provision only requires the contractor to provide indemnity for losses caused by the negligent acts or omissions of the contractor, its subcontractors, or its employees. Now, this is also important because it is not uncommon to see one party required to provide indemnity where fault is shared or where the other party is solely at fault for a loss. Ultimately, state anti-indemnity statutes might stop this from happening, but it's best to always make sure that these types of overreaching indemnity provisions don't find their way into your contracts in the first place. The next provision that I want to talk about is agreement terms. As it relates to master agreements, it's not uncommon to find that parties are still performing maintenance work under work orders after the term of the maintenance agreement has expired. If this happens, what this does is it causes a potential for ambiguity over whether the work order itself is valid or whether the terms of the master agreement even still apply. Because of that, the master agreement includes a default 1-year term that can be modified. And if the master agreement is not extended, renewed, or terminated at the end of the initial term, it will automatically continue on a month-to-month basis until the parties take action to either extend, renew, or terminate. Now, the purpose of this auto renewal is to ensure that the terms and conditions of the master agreement continue to apply to work orders that are executed under it. You're going to find the same agreement term in our standalone agreement, the F103 maintenance agreement for ongoing work. On the other hand, I should note that our standalone agreement for the F102 maintenance agreement for as needed work, that includes an agreement term that consists of a commencement date and a completion date. And that's mainly because it contemplates a type of maintenance work that can be completed within a certain period of time. The last thing that I want to note is some of our highlight is some of our termination clauses. Um, as it relates to our maintenance agreements, termination provisions exist for both the contractor and the client. Now, as it relates to the contractor has the right to terminate an agreement if the client fails to make payments and doesn't resolve the issue. In this case, the contractor can recover payment for work that was done before the termination and any cost incurred due to the termination. Additionally, if the maintenance work is suspended for 30 days due to no fault of the contractor can terminate the contract and recover payment and cost. And finally, with respect to the client can terminate the contract if the contractor materially breaches the agreement and fails to remedy the breach. And the client can also terminate for convenience without cause. Now, this does require a 30-day notice. And if the client terminates the contract for convenience, the client must pay for the work performed and reimburse the contractor for costs incurred due to the termination. Now that I've talked to you about the maintenance contracts that we offer, I'm going to turn it over to Mike to talk about some of our consulting agreements.
Awesome. Thank you, Elisa. And I know we're getting up on the 30 minutes past the hour, which is the end of our time, but I do have two more documents to talk about that I think are important in this facility management bundle of documents. But I think that all of the things that, Elisa, you just said really underscore, if there's one thing to take away from this webinar today, it is that maintenance contracts are very different from construction contracts. And in the process of developing these maintenance contracts, we have talked with quite a few attorneys, practitioners in this industry who have attempted to do their own work to modify a general construction contract for maintenance activities. And we have universally heard from folks that it is very difficult to do. We've experienced it, Elisa and I have ourselves. As attorneys. And so just know that we've done the work for you. We've got documents out here that are streamlined for maintenance contracts. And I would hate to see people go through all of the hardship of trying to modify a document when we have something out there that is just better suited for it. So the last couple of documents, I want to talk about are for instances where a property owner might need to hire consultants to perform services on an existing building. So not maintenance contractors, but consultants of a variety of types. And this is for this reason that we developed the F301 standard form of agreement between client and consultant. This is an agreement that can be used to hire a wide range of consultants on an existing building. For example, you can use the F301 to hire facility managers, property managers. You can also use it to hire security consultants, environmental and energy consultants, and you can use this document to hire architects and engineers as well. And there are many reasons why you might need to hire these kinds of design professionals on an existing building. So for just a few examples, architects are often needed to do things like area calculations, space planning exercises, migration planning because most buildings are in a constant state of change depending on personnel needs and just operational needs of a building. Also, structural engineers are often required to do things like structural inspections, facade inspections, to make sure a building continues to be safe as it ages. The F301 contains the key business terms like termination provisions, dispute resolution provisions, and provisions dealing with insurance. It does not, however, contain a scope of services. So you're going to need to attach or refer to a scope of services document in order to make this a complete agreement. Oftentimes, you can do that by simply referring to a scope of work description in the consultant's proposal. The better practice is to literally excerpt out the scope of services or scope of work description and use that as just a standalone like exhibit to this F301. There's one scope of services document that we have created. That's the F311, standard form of consultant services facility condition assessment. We created this scope because it is extremely common type of an activity that you're going to find being done on existing buildings. Facility condition assessments are often done prior to the sale of a property so that the party who is purchasing the building understands the condition of the property they are purchasing. They are also commonly done before large-scale renovations are undertaken, again, to understand the condition of the property before work is planned on it or is actually done to that building. The F311 document includes a menu of services for the consultant to perform, including activities like reviewing existing documentation, performing code reviews, examining site features, and so on. Very few consultants are going to be able to do all of these services themselves for all the various components of a building. So it's not at all uncommon for facility conditions assessments to be done by a team of consultants with one, perhaps an architect, leading that effort. So with that, we have, first of all, I want to thank everyone for joining us on this webinar. I am going to turn it over to Nadia, who's going to jump on here and talk about contact information and resources to all of the various resources and whatnot that we have at AIA Contract Documents. Nadia.
Thanks so much, Mike, to both you and Elisa for guiding us through the various nuances of our facilities management bundle. There are many ways to contact us for resources or to see our articles. You can visit our Learn page provided for you on the screen. To access our facilities management subscription, you can visit our website at shop.aiacontracts.com/facility-management. If you have questions about our documents, you can reach out to us by phone or email. To request a software demo, please email us at sales@aiacontracts.com. We're excited about this addition to our offerings and the opportunity to pass more value on to you. Using these documents will help you realize efficiency increase, risk reductions, cost savings, and much more. For